Hi, my name is Dana Collette. I teach business law at Vancouver Island University in British Columbia, Canada. This short slideshow provides information only. It's not legal advice. You should speak with a lawyer if you have a problem that requires legal advice. To find a lawyer in BC, call the Lawyer Referral Service or go to their website. This slideshow will introduce the sources of law within the common law system in Canada and will focus on all of Canada outside of Quebec, which adopted the civil law legal system for private law matters. Hundreds of years ago, common law began with courts looking to the customs and traditions of the people at the time in England when making their decisions. The courts also looked to other sources at the time, such as law merchant, canon law, and Roman law, when appropriate to the circumstances of the case. Eventually, a system of law emerged whereby courts must follow the decisions of higher courts. This is called following precedent under the doctrine of stare decisis. Stare decisis means let the decision stand. Common law is core to our system and the reason why our legal system is called common law. A good example of common law is when someone is suing for breach of contract. Much contract law comes out of court decisions. Equity is a body of law that develops separate from common law. Originally, it was in response to the common law not providing an appropriate remedy in certain circumstances. In its early evolution, the common law was quickly becoming quite rigid, and in some particular circumstances could lead to an unfair result. People went to the king to ask for a remedy. This eventually led to a separate court system being set up to hear cases under equity. Equity and common law are now heard in the same courts, and both follow the doctrine of stare decisis. A good example of equity is when you ask a court for an injunction to stop someone from doing something. An important part of our legal system is legislation. These are laws enacted by our governments. Both provincial and federal governments have the power to make laws under our Constitution. Also, because of the concept of parliamentary supremacy, those laws can override common law. A good example of legislation is the myriad of laws written by governments that affect contractual relations, such as the BC Sale of Goods Act and the BC Business Practices and Consumer Protection Act. The Canadian Constitution is supreme law in Canada. That means that no law in Canada is valid if it goes against the provisions of the Constitution. Two examples from the Constitution are the Division of Powers and the Charter of Rights and Freedoms. The Division of Powers provisions list in which areas provinces and the federal government may make laws. For example, provinces may make laws in listed areas, including the management and sale of provincial public land, management of hospitals, municipal governments, property and civil rights, and education. Federal government may make laws in areas not assigned to provinces, including unemployment insurance, postal service, military, banking, legal tender, patents, copyrights, and criminal law. The Charter of Rights and Freedoms sets out the ways that we are protected from government action. For example, the right to vote or run for office, our rights regarding how we're treated if arrested, and the right not to be discriminated against on certain grounds. In summary, we get our laws in Canada from the following sources: common law, equity, legislation, and the Canadian Constitution. Thanks for viewing the slideshow. I hope this short introduction to sources of law was helpful.